We're gonna call 26CF58, State of Wisconsin for J.C. Johnson. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Attorney Niels Wiesnick. I appear along with my client Jay Johnson, who appears before Your Honor in custody.
All right, I've looked over the criminal complaint. I'm gonna find probable cause as to the misdemeanors. Counsel as to plea on the misdemeanors.
Not guilty.
I want to not guilty plea. We'll deal with the felony after we hear bail bond argument, counsel.
I have no objection to a signature bond in this case. I would ask that the defendant have no contact with SMJ and that the defendant be banned from the 3700 block of North Fair Oak Road and also be banned from any place SMJ temporarily occupies. The victim in this case is in agreement with the no contact and address ban. So that's where we're at.
Any objections to the non-monetary conditions?
Judge, we have no objections for the most part to the non-monetary conditions. There is the issue that the Fair Oak Road address is a home that is owned and shared by my client as well as the alleged victim in this matter. My client has his entire life that's located there. He would request an opportunity to make one trip there to collect his belongings.
Sure, with police supervision, he can make one trip there to pick up his belongings. As to the signature bond, we'll do $500 per count. As to the felony and the preliminary hearing, are you waiving time limits or do you want to proceed under time limits?
We will waive time limits.
All right, we'll waive time limits. Anything else, counsel?
No, thank you.
We'll be adjourned. Thank you.
Thank you. I'll take that with you.
Next up is David Sanders.
Yep.
108.
Who's that here?
Sanders.
Thank you.
All right, so.
Sure, not a problem. Then are we working on getting Mr. Johnson, Henry James remotely? Because I think Attorney Valerio, you have to leave, right?
I just need to step aside for a different prosecutor to take over that particular case.
Okay.
So, right now we have David Sanders coming up.
500 per count.
When it's ready, Henry Johnson, they're gonna let me go with the radio.
Sounds good. Thank you.
They're aware from
I appreciate it. I'm not trying to put pressure on you guys. It's just I thought Attorney Valerio had to leave, but it sounds like it's more he just has to step aside on that one.
Yep.
Oh, sorry about that. My vision's so good. Yes, sir. No, that's all right. You understand, vision's bad. Where do you want to ask for? No contact. I'll do that. I don't answer. I can do that. What I do, I do.
Yes.
Yeah. I can see them.
This one, the victim by phone, we have to go phones or? All right.
Yeah, I can send it all over you. Yeah, I'll accept it. You said it's a button? Here. Oh, I can see.
All right, court's gonna call, thank you. Court's gonna call 26CM70, State of Wisconsin for David R. Sanders. Appearances, please.
State appears by Assistant District Attorney Thomas Valerio.
Mr. David Sanders appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. I would waive its formal reading. I can confirm that the address on it is accurate. It would appear that he is eligible for public defender services, and we would stand mute as to the misdemeanor charges.
All right, court's gonna answer not guilty pleas as to the misdemeanor charges after finding probable cause after review of the complaint. We have a victim that I believe may want to make a statement before we deal with bail bond. To victim witness services, do you have the victim on the phone there?
Yes, I am.
All right, ma'am, you wanted to make a statement?
Sure. I don't want to press charges against David. We do have in common grandchildren and children. I don't know what to say. Like, I don't want, I don't.
We had a domestic dispute.
We had domestic dispute. I don't want him to not be in our life. Okay, that's it. That's it.
All right. Sure. The way I'm understanding it is that you're okay with having contact with them. It's actually in Wisconsin, the district
Yes.
attorney decides whether to press charges or not. But I understand that'll be taken into consideration. Today is simply an initial appearance, but it's my understanding, ma'am, and correct me if I'm wrong, you would like to have contact with Mr. Sanders. Is that correct?
Yes, sir, because we do have children together
And grandchildren.
and grandchildren.
Understood.
So
Go ahead.
I'm done.
All right, I appreciate the statement.
The court, court reporter will just need either initials or something like that.
Sure. Let me give you some initials here. SNW.
Thank you.
All right, Attorney Valerio has the bail bond here.
I have no objection to a signature bond. I would ask that the defendant have no contact with Sarah W., that the defendant be banned from the 800 block of West Main Street in Sun Prairie. It looks like this is an incident where I don't believe there was any prior convictions associated between Mr. Sanders and Sarah W. Still, the facts are certainly concerning. This incident started when the victim was sleeping in her chair, and then Mr. Sanders woke her up by pushing her, saying something like, "You heard me calling B word." This frightened the victim so much that she,
Ma'am, hold on, ma'am. Ma'am, I heard your statement. Today, it's based on allegations. I'm going to hear from Attorney Valerio. Then I'm going to ask counsel, who I assume is going to want to argue for no acts or threats or violences, and then I'm going to make a decision here.
the victim
know
said
what
that
that
this.
means? Well, ask him what it means.
Can we mute her? Thanks. Thank you. Go ahead, counsel.
The victim said that this frightened her so much she pushed the defendant, scratching him in the process. They found bite marks on Mr. Sanders, which was consistent with the victim's story of events. It's alleged that the victim indicated that the defendant pushed his forearm into her neck, which caused the chair she was sitting on to be pushed back 4 to 5 feet in the kitchen area. She said she couldn't breathe when Mr. Sanders was pushing on her neck, and that's when she indicated that she bit the defendant's hand, breaking the skin, causing it to bleed, as well as scratching him with her nails to get him off of her. He also made a specific statement, according to her, saying, "B word, I'll kill you." And then the victim had to rip the defendant's shirt and was able to distance herself from the defendant when the defendant got to get a new shirt. She had to go to her neighbor's apartment, who allowed her to call the police. And then victim and defendant then came to the neighbor's apartment, where I believe the defendant was trying to knock on the door, trying to get in. She enforced a 72-hour no contact at the scene. I recognize that she's indicating she doesn't want to press charges. She wants Mr. Sanders in her life, but bail conditions are meant to protect the public. And I think that during the pendency of this case, Sarah W. needs protection from Mr. Sanders.
Go ahead, counsel.
We would join in the state's request for a signature bond, and the court is correct. The defense will be asking for a condition of no acts or threats of violence towards Sarah W. I would just say in support of that, one, Sarah W.'s own statements that she wanted to have contact with Mr. Sanders, that they have a family together, that they have children, they have grandchildren. And then I would also just mention, the court is allowed to consider strength of the evidence, credibility, even affirmative defenses when setting bail conditions. And I do think it's an open question of how this altercation started. For instance, just from what's alleged in the complaint, the alleged victim does essentially say that she was the one who started the physical altercation, that she had first pushed Mr. Sanders, if I was reading the complaint correctly. I would also note that Mr. Sanders does have multiple visible scratches on his face. Self-defense could potentially be an issue here. One moment. Given that, I think it's not entirely clear. Sorry, I also wanted to mention, just on the point of credibility, the alleged victim did claim that there was a lengthy period of strangulation. No strangulation charges were brought. Officers did note that they did not see any bruising on her throat. So I think it's an open question of how this altercation started. And given that, I would ask for a condition of no extra threats of violence towards Sarah W. Thank you.
All right, Mr. Sanders, I'm gonna do the signature bond at $500 per count here, meaning you don't have to post that, you just have to sign out on, but if you get picked up again, that's what you're gonna have to post to get out.
Yes, sir.
Understandably, I understand this is a family situation. You have children and grandchildren with the alleged victim. I'm hesitantly gonna do it, but I'm gonna do no acts or threats of violence, and I mean that because if any other occurrences occur, it's not going to go as well for you next time. I hope you understand that. I understand these are allegations. It looks to me from your demeanor that you're denying the allegations, but that's not for me to determine today. But it's for me to determine what I believe is going to make the public safe. And I think if I do no acts and threats of violence, I'm hopefully not mistaken, and I'm confident that you're going to comply with that. Do you
Yes,
understand
sir.
that? All right. Is there anything else, counsel?
No.
All right, we'll be adjourned.
Yes, sir. Next up is Henry Johnson, appearing by Zoom.
All right, did I get that all wrong? You're the one who has to leave, right? That's
me.
I was like, okay, I'm not getting something here, but now I get it. Let me call this one as soon as we're ready on this end.
I was told that there might be some connectivity issue. You can phone thing now, but if it cuts out, I can freeze it.
Okay, we'll do our best here. Court's gonna call 26 CF 59, State of Wisconsin versus Henry James Johnson. Appearances, please.
Lexi Keys for the state of Wisconsin.
Mr. Henry Johnson appears by Zoom video conference from the Dane County Jail alongside attorney C. Joseph Ventola appearing in person. Mr. Johnson, first I'm going to ask, I think your audio is on, but can you just give me a thumbs up if you can hear me?
There's some noise, but yes.
Okay. Mr. Johnson has indicated that he can hear me. Mr. Johnson, have you received a copy of the criminal complaint in this case?
Yes.
Okay, and the address on it, 5257 University Avenue, apartment 308. Is that a good mailing address for you, sir?
Yes.
Okay. So we would waive formal reading of the complaint. I cannot verify his eligibility for public defender services at this time, and we would stand mute as to misdemeanor charges.
All right, the court will enter a not guilty plea as to the misdemeanor charge after finding probable cause after review of the complaints. We'll deal with the felony at the end here after bail bond. May your argument, counsel?
The state is requesting $40,000 cash bail with the non-monetary conditions that he have no contact with A.R.J. or any member of her family, that he be banned from the UW campus area, that he be banned from all of Seneca Place located in Madison, that prior to his release, he be outfitted with a GPS monitor and be monitored by pretrial services, that he have no contact with any member of law enforcement, the district attorney's office, or the court staff outside of the courthouse. This defendant was previously prosecuted for disorderly conduct related to this specific conduct. During the course of that prosecution, he showed up at the home of his assistant district attorney at night to discuss the case. The defendant had contact with that ADA's family. Eventually, that case was ultimately dismissed, given the cost-benefit analysis of prosecuting the case and putting the victim back in contact with Mr. Johnson. That was too high in our estimation. However, he was specifically warned in writing when that case was dismissed that the injunction prohibiting contact was still in place and was told not to contact the victim. Less than a month later, he did it again. When police spoke to him, he seemed to indicate he would continue to contact the victim if he wanted to. There has been an injunction, a stalking warning letter, and a prosecution related to this behavior, and it's pretty clear at this point he will not stop. It is an Act 3 offense, and the prolonged and continuous unwanted communication from the defendant is causing the victim and her family significant emotional distress. The defendant has continued to contact the victim and her family after having been given a stalking warning letter and having been issued an injunction. Additionally, given the contact of the assigned ADA at the time at his residence, significant cash is clearly appropriate to ensure the safety of the victim and the community and to help ensure that he follows his bail conditions.
All right, counter argument?
I would just start by asking Mr. Johnson, did you understand the conditions as proposed by the state?
To an extent.
Was there anything that you did not understand? And if you would like to talk privately, there's probably a way that we can arrange that.
I suppose, we could talk privately. I just don't understand the GPS being necessary because I don't go to any of those
Well,
locations.
Mr. Johnson, I'm just going to ask that
Yeah.
you not say anything specific about this case.
No, it's
Every
not about the
single
case,
word.
but that was part of the bail,
Mr.
right?
Johnson,
Mr. Johnson, I'm gonna advise you not to say any statement, because I'm pretty sure anything you say is going to be against your self-interest.
and if I may, Judge, I'm sorry.
No, go ahead.
Ms. Johnson, I want to make very clear to you, every single word that gets said in this courtroom gets recorded. That means every single
Understood.
thing that you say could possibly be used against you. I'm going to ask you to please not go into any kind of specifics. If you'd like to talk privately.
No, I understand.
okay.
I
Okay.
thought that was.
Mr.
part of the
Johnson?
ba- You asked me about the bail, right?
Yes, would you like to talk privately about that?
If I heard it correct, yes, I wasn't clear on the ankle monitor.
Okay. The requested conditions are that you have to report the pretrial services before you're released. That's only after you were to post 40,000 in cash. Wisconsin is not a bail bond state. You can't post a percentage. You have to post the whole 40. That you would have a GPS monitor on you before you would be released. Those are the conditions that they're in. Clearly no contact with the victim here. Those are the conditions that are being requested. Now it's time for counsel to make a counter argument or not, or concede those conditions. But if you guys want to talk about your position, we will let you do so. What would you like to do, Mr. Johnson?
I would like to ask why those are the conditions when I never go to Seneca Place or you.
Mr. Johnson, I'm going to ask that you not say anything else.
Yeah, you can't ask questions. My question was simply, you understood the conditions. Do you want to talk to counsel or do you not want to? And he'll make an argument for you and I'll make a ruling. That's all we're doing today.
How would I talk to counsel?
We'll make it happen.
We can, I believe they have yep, we can do a breakout room and I can talk to you separately on a computer away from everyone else.
I don't know how to proceed. I would let you do your thing. I don't know what's going on.
Do you want to speak to me privately?
If it's beneficial,
I'm going to ask to speak to him
Yeah, speak
privately.
with them. Speak with them.
So, come on out. Our computer, all set up, it's imitate from the and may work.
Sure.
Thank you, Judge.
No problem.
Are there any FOs we can do, or
What's that?
are there any more FOs we can do in the meantime?
I think I'll be back quickly.
Oh.
Yeah, and then we'll get you out of here. And I've seen your name on many documents. I just don't remember seeing you in person, so.
What's gonna happen is you're gonna have to get another computer. They're gonna link to this one. We're gonna break our own see their attorney.
We gotta do a
Talk
breakout.
freely because I am part of the court system and I can't report what you
See
say.
it?
Okay?
All right, here, I'll let you do it, okay.
It's just gonna take a minute.
We're in there. So no problem. Yeah, go to assign manually and then hit create, and then you should hit the assign at the right there, it says assign, and then put them in there. And they are so trash. Which one was it? He was in the middle. It's hard to tell. IA Court Bailiff. And which other one? And then at the bottom there, IAA bailiff. So assign that one too. I think you could hit room 1 and reopen. Yeah, there we go. Yeah. So then open all rooms, so we should be good. Sweet, all right. Gonna be later, no worries, we only have 14 today, so.
Hey.
We're both pretty quick, so we won't be here that long.
I don't think a lot of them are gonna be that,
No, there's like 3 forfeitures. Or the one we already did one, so there's 2.
deal.
We'll get you guys over to the post as quick as possible.
So.
I always find it hilarious when commissioners go in there, you guys walk right past us like you don't see us. We raise our hands and try to say hi. Oh, yeah. Yeah, let's do that.
Fine.
So first up will be DAVAIRICK Jefferson.
DAVAIRICK Jefferson.
Mr. Jefferson.
Let me find that one. All right, Mr. Jefferson, let me call your case. We'll call 26 FO 41 Dane County versus DAVAIRICK Jefferson. We're simply here on a forfeiture. What that means is you have not been charged with a crime. There are 2 municipal violations for disorderly conduct and county bail jumping. Is there an offer, counsel?
Yes, the offer would have. Excuse me, sorry. The offer would have Mr. Jefferson plead no contest to count 1 of the forfeiture complaint. Count 2 would be dismissed outright, and then the recommendation would be court costs only.
Okay, do you remember what that amount is? 115.50? 114.50. All right. Mr. Jefferson, what that means is that they'll dismiss count 2, so like it doesn't exist, okay? This isn't criminal, so it's not read in or anything like that. Count 1 is simply a county disorderly conduct that you did something that was loud and boisterous or otherwise inappropriate. You'll plead no contest to that. You don't have to plead guilty. And then you pay a fine of $114.50. Does not have to be today, paid today. If you can pay it, that's fine. Otherwise, you can make arrangements to pay it over the next 60 days. How would you like to proceed?
Explain one more time.
Sure, not a problem. Count 2, the county bail jumping would be dismissed outright.
All right.
Okay, like it didn't happen, right? For legal purposes. Count 1 is just simply county disorderly conduct. It's a ticket. It's not a crime. It's not a criminal offense. It's nothing you need to report for any licensure or anything else. The fine for that is just the court cost, not a fine. It's just court costs. $114.50, which you can make arrangements to pay over the next 60 days with the clerk. You'll be released today. Either way, even if you plead not guilty today, you could be released. If you plead not guilty, the offer may not be in the future to dismiss the second count. What would you like to do?
I'd take.
You like to pay the ticket? Okay, so we're gonna dismiss count 2. I'll accept the no contest plea to count 1. You'll be released today. There'll be information for you as to how to pay that ticket or to make arrangements for a payment plan, okay?
Okay.
All right, best of luck to you.
Thank you.
Right, next up is KARISSA SCHAPER for forfeiture.
Sure. Correct. All right, court's gonna call 26 FO 43 Dane County versus KARISSA M. Schaefer. Appearances, please.
The county appears by Assistant District Attorney Thomas Valerio. The defendant KARISSA M. Schaefer appears in person in custody without counsel.
All right, Ms. Schaefer, this is simply a forfeiture, which means you haven't been charged with a crime, okay? After the DA's reviewed the facts of the case, he's decided to charge us a forfeiture, which is a fine. It's county disorderly conduct. Is there an offer on the table, counsel?
Yes, it would be plead no contest to the sole count for court costs only.
Okay, so what that means is you would plead, if you wanted to, you could plead no contest, which means you're not contesting the charges. I would treat you as as if you were guilty, and I would impose a fine or simply asking for court costs of $114.50. And that would conclude the matter. You could make arrangements to make payments on that if you don't have those funds. Either way, even if you plead not guilty today or you accept the offer, you're gonna be released today. What would you like to do?
What? I mean, technically it won't be released because I'm both.
Unless there's other holds, you're correct, okay.
But, I figured, is there a way that I could sit, even if I pleaded no contest, sit for the fine amount?
No, it's just a fine, it's forfeiture. I don't have the authority to hold you on a fine.
Okay,
I have the authority, you're gonna be held if there's other issues out there.
yeah, okay, I guess I'm thinking of that.
All right, we'll take the no contest, make arrangements to pay that fine. When you're released, as you deem fit, we'll be adjourned. Thank you. Best of luck to you.
Right, Swan? Okay.
You want to close that breakout room for me? Yeah, there we go. Yep, we're just, it'll be a few seconds, like 50 seconds before he's back. Then you can run to your prelim.
Yeah.
This job involves a lot of scurrying around.
Exactly.
Being in 7 places at the same time, it's
I
fine.
was there. But it's never boring.
I was like that yesterday. I had to be in 2 Zooms at the same time, and luckily something settled that I had to appear. I was like, somebody's waiting. Whoever gets in first is the other party's waiting. We'll figure it out. Still waiting here.
I'm present.
All right, there we go. You've had the opportunity to speak. Well, we're back on the record. You've had the opportunity to speak with your client. Counsel, what would you like to argue?
Yes, I've had an opportunity to speak to Mr. Johnson, and in line with the PSA filed on this case, I'm going to be asking for a signature bond for Mr. Johnson. $40,000 cash bail is a pretty high amount for any person to post. I have no indication that that's an amount that Mr. Johnson would be able to post. The fact of the matter is, Mr. Johnson has no criminal convictions on his record. And I know the state made a point of talking about the cost-benefit analysis of his previous case, but the simple fact is, a dismissed charge means that legally, Mr. Johnson is presumed innocent of that charge. He has no criminal record at this time. I would also note that the contact that is alleged in the complaint does not involve any acts or threats of violence, at least from what I was able to see. I'm sure the state will correct me if I'm missing something. The public safety assessment filed on this case notes that this is a 1 on the new criminal activity scale and a 1 on the failure to appear scale. On that one other case that he had in 2025, he made all of his court appearances while representing himself. I would also, if the court is inclined to issue cash bail, I would ask that it's in a relatively minimal amount. I don't believe that Mr. Johnson has extensive financial means to post a high amount of cash bail, but I think that just given his circumstances, $40,000 is a pretty extreme amount. And we would not object to the non-monetary conditions. I guess I'll also just say briefly on that, the non-monetary conditions should be sufficient to ensure the safety of the public, given what is alleged. Thank you.
I'll ask for a reply here.
I think at this point, cash bail is absolutely warranted. He has indicated to police that he would continue to do this. There's been a stalking warning letter, an injunction. He has been charged for behavior related to this. He has made it pretty clear that he won't stop this behavior, and it is an Act 3 offense. The protection of the public is something that the court is to consider. And I think taking that into consideration, a $40,000 cash bail is absolutely appropriate here, and that's what I'm asking that the court do.
All right, the court's gonna go with the non-monetary conditions here, the pretrial services before he's released, GPS monitoring. I'm looking at the acts that are alleged here. I do agree with counsel that the last one was dismissed. I'm not taking that into consideration. What I am taking into consideration is the fact that he had plenty of warning not to do the conduct that was alleged to have occurred here, and it happened anyways. I don't think there's any confusion as to what kind of contact he could have with the alleged victim. I am gonna do cash bail. Cash bail is gonna be at $25,000 cash. And we're gonna be adjourned unless there's anything else from counsel.
I think we just have to address time limits.
Oh, time limits as to the felony.
Will not be waiving.
Okay, we're not waiving time limits on that one. Now we're adjourned. Thank you.
Next up is Keith Fowler.
What's the next one? Fowler. Okay, just give us a second here. Sorry.
Okay. Just ask, is that a good mailing address for you, sir? Yeah. Spoke with the office today, change into that. Okay.
All right, court's gonna call 26 CM 69 State of Wisconsin for Keith L. Fowler. The second appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Keith Fowler appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct. It would appear, Mr. Fowler has represented to me that he has spoken to the public defender's office today and that they have just recently deemed him eligible for public defender services. And we would stand mute as to the misdemeanor charges on this case.
All right, after review of the criminal complaint, the court's gonna find probable cause here. And we'll go ahead and accept, enter not guilty pleas with regards to bail bond.
Commissioner, I think the victim is online and would like an opportunity to speak.
I apologize, you're right, that's on the list for victims. Before we hear bail bond, as ma'am, if you would like to say something, I would accept that statement now. You're muted. LB are the initials. LB are the initials. This is Fowler.
Hello?
There it is. All right, go ahead, ma'am.
Yes, I've contacted the DA Victim Witness Unit and spoke with her. She informed me that I was to contact the police department. I tried to include omitted information as far as my police reports. And they said at that point it was too late. So I just they told me to come here and offer my suggestion of that I do not want a no contact enforced.
All right, understood. You would like to have contact with Mr. Fowler. And then I'll hear arguments from counsel, and then I'll make a decision as to that issue. Go ahead, Attorney Valerio.
I have no objection to a signature bond. I would ask that the defendant exhibit no acts or threats of violence towards Leanne B. For the record, I believe her first name is spelled Leeann. Leanne, did I get that spelling right? Okay, I think I saw your head nod. I appreciate it. Thank you.
That's correct.
Thanks.
Thanks. Any objection, counsel?
Thank you.
All right, $500 signature bond per count and no acts or threats of violence. Best of luck to you, sir.
All right, swear this way. Next up is Andrew Berg.
Okay.
Nice to meet you, sir. I talked to your attorney, Sophia, this morning. She and I work right next to each other. Still a good address? Is there someone you'd prefer to get mail? Okay.
All right, court's gonna call 26 CM 72 State of Wisconsin versus Andrew R. Berg. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Andrew Berg appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the mailing address on it is correct. We would stand mute as to the misdemeanor charges, and it would appear that he is eligible for public defender services. He is currently being represented by an attorney in our office.
All right, court's going to find probable cause after the review of the criminal complaint. Enter not guilty pleas as a bail bond.
I'm requesting a $500 cash bond in this case, along with the condition that the defendant have no contact with TCB. Mr. Berg had a warrant issued for him bench warrant issued for him on May 18th of 2023, which was quickly served on him a few days later. And in this case, while he's under revocation proceedings for domestic violence cases with the same alleged victim in this case, he's calling her from the jail on another inmate's tablet when he has no contact order in place. He's violating a specific no contact condition. There's the previous missed court appearance. I think some cash is needed.
He's in revocation proceedings. He's not getting out regardless, right?
That's well, I don't know. Those aren't going to last forever.
Sure. Go ahead.
I did talk to his assigned attorney, Attorney Stingle. It's unclear if there's a revocation proceeding going on, is what I would say. One thing that is for sure is that he is going to be serving a sentence in the Dane County Jail until March 23rd of this year regardless. So there's at least another about 2.5 months where he will be in custody. I'm not going to object to the non-monetary conditions, but I am going to ask for a signature bond. There has not been any allegations of any violent contact in this latest incident. It's also, again, I talked to his attorney. He has a very good relationship with his assigned public defender. She said that I know the status of his probation is a little unclear. If he is released on March 23rd, he might continue to be on probation. Again, it's unclear what the exact status of that is, but I do believe that there is a fair bit of monitoring that will be in place on Mr. Berg already. And at this time, cash bail is just unnecessary. He's going to be in custody for another 2.5 months on a relatively minor misdemeanor case.
I tend to agree with you. It's just kind of strange when people offend while they're in custody, so I'm gonna have him post something small, $250 cash bail. If he can't post that in 2 months when he's up to get out, ask for a review hearing, it'll be reconsidered.
I need a sentence next week on Friday.
Is there anything else, counsel?
Not for me.
Or not this, but.
Anything else, counsel?
If I may just have one moment to speak to Mr. Berg. Nothing further. Thank you.
Okay. Yeah, no contact continues. You understand that no contact continues? Sure, okay. All right, we'll be adjourned.
Next up is DEMARION Edwards.
Mr. Edwards, nice to meet you, sir. Nice to meet you. Just here from the Public Defender's Office to represent you today. Is that a good mailing address for you?
Yeah.
Okay.
All right, court's gonna call 26 CM 73 State of Wisconsin versus DEMARION S. Edwards. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. DeMarion Edwards appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct, and I do believe that he's been deemed eligible for public defender services. It appears he's currently assigned a public defender on one of his pending matters.
All right, courts review the criminal complaint as to count one, I'll find probable cause, enter not guilty plea as to bail bond.
I have no objection to a signature bond. I would ask that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
No objections, thank you.
So entered, $500 signature bond. We're adjourned, you're free to go.
Next up is Jerry Saul. Okay.
I'm from the public defender's office and just here to represent you for your initial appearance today. Okay, all right.
All right, court's gonna call 26 CF45 State of Wisconsin versus Jerry and Saul Jr. We're here one felony, one misdemeanor count. The appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Jerry Saul appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. One moment. Is it that one? Yeah. Okay. We're gonna make a correction to the mailing address on the complaint. It's gonna be S2834 Decorah, DECORAH Road, Baraboo, Wisconsin, 53913. We will waive formal reading of the complaint. Stand mute as to the misdemeanor charges, and it would appear that he is eligible for public defender services.
All right, court's gonna find probable cause after review of the complaint as to the misdemeanor. Enter not guilty plea. Counsel as to bail bond.
I'm recommending a $1,000 cash bond in this case. I'm asking for conditions that the defendant not operate a motor vehicle, that he not use or possess any controlled substance or drug paraphernalia without a valid prescription. What matters here is the fact I don't see any recent failures to appear, Commissioner. Though what's concerning from a bail perspective is that Mr. Saul was on probation for 24 months since December 5th of 2024 for possessing drug paraphernalia and possessing an illegally obtained prescription in Columbia County case number 23 CF 239. And while he was on probation, only about a year in, he allegedly commits the offense for which he's in custody for now. Law enforcement sees him in the driver's seat. He had his eyes closed even after law enforcement, I believe, knocking on the window several times. He didn't respond. Currently, we're waiting on blood results in this case, but it appears they PBT'd him at 0. So it appears that this is a drug-related case, which unfortunately appears consistent with the fact that which, you know, he's on probation for drug-related things. So bottom line, I think it's a cash bail case. There's a mandatory minimum prison sentence if he's convicted. I think that in and of itself creates some risk of flight. But furthermore, the fact of the matter is he was on probation, probation for drug-related conduct. So I think some cash is appropriate.
Go ahead, counsel.
I would first start by noting, well, I'll first start by saying that we do not object to any of the non-monetary conditions that the state has proposed. Then I would just want to say that Mr. Saul is being held on a probation hold, which is to say, no matter what the court decides today, he is not being released today. And then from there, I do think a signature bond is appropriate on this case. As we've discussed previously, strength of the evidence is one of the factors the court is allowed to consider when setting cash bail. You know, I'm not the world's most experienced attorney by any stretch of the imagination, but I have worked on a fair number of OWI cases to this point, and the indicators of his impairment are relatively minimal compared to many of the cases that I've seen. He PBT'd at 0s. You know, the clues that they have on the standardized field sobriety tests were less than we typically see. That's not challenging probable cause at this stage, but the evidence of an OWI is not as pronounced as we typically see. I would also just want to note, he has lived in Wisconsin for the last 25 years. He has children aged 6, 9, 11, 16, and 23. My notes indicate that they all reside with him. I think he has significant ties to the community. I think that there are potential triable issues here, and he will not be released today, no matter what the court decides. So I don't think a cash bond of $1,000 is appropriate. I would ask for a signature bond. Thank you.
Yeah, I mean, the allegations is a 5th or 6th OWI. He's appeared for court on the other 3 or 4, how many it's been at this point. The indications are he was sleeping in a vehicle. He has a past drug history. I don't know that necessarily. I mean, I wish we had results back, but they don't come back in any timely fashion. We both know that. I'm confident he's going to appear for court. I'm going to give him a signature bond. It would be a $500 signature bond per count. With regards to time limits on the felony. Pause here to determine if there's. Makes sense.
We're not going to be waiving time limits. Thank you.
Now we. All right, we'll be adjourned. Thank you.
Commissioner, the non-monetary conditions.
They're all, there was no objection. They're all included.
Okay, thank you.
Saul.
Next up is Tiger WAHTOLA, appearing by Zoom. Just so the court is aware, Mr. WAHTOLA is declining to participate. They're set up outside of his cell.
All right, understood. We're gonna proceed whenever you're ready. Yeah.
He's been provided with a copy of the criminal complaint at the bottom of the cell door.
All right, appreciate it.
He took it in now, so.
All right. All right, court's gonna call 26 CM 68 State of Wisconsin versus Tiger J. WAHTOLA. Appearances, please.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Attorney C. Joseph Ventola appearing in person for Mr. Tiger WAHTOLA.
Hold on, counsel, before you go. I just wanted the appearances on this one's strange because just so you guys are aware, I signed a restraining order earlier this week for him not to be at the location that he's alleged to have been at now twice this week because he showed up on my probable cause emails in the morning twice now that I've found probable cause for. You can ask for a different commissioner and we can set this over, or you can have me proceed. I'll let defense counsel decide.
May I just have one moment to speak to the state?
Sure.
Yes. Like the me. Then I'll probably ask for something.
I think if it's going to be disputed, then I'm going to ask for it to be sent over.
Okay.
I spoke to the state. I think there's going to be some disagreement over whether to impose cash bail. So given that, I think it would be appropriate to request a set over for a new commissioner. Thank you.
I would agree. I've seen alleged conduct all week, so we'll set this one over. Josiah, do you know when it gets set over? All right, we could probably get it in tomorrow then. All right, we'll do that. Mr. WAHTOLA, you'll be appearing tomorrow and things will be decided then. We're going to be adjourned. Thank you.
Next up is ELAINE KARPINEN.
Something that was, hospital,
Who's that? No, he's from the public defender's office. I'm just here to represent. Is that his second charge this week, Attorney Valerio for WAHTOLA? He's the homeless guy who straight into the third and staying there.
Yes, I know something. It's awesome.
Okay.
Well, I think, I don't know if that's a second charge this week.
Do you want to get your mail at the Beacon?
I mean, I
But
haven't signed his restraining order.
It was 2 different incidents
Yeah.
in the same
You
complaint.
charge him once.
Okay.
Yeah, and it's not much that.
Okay.
No, I have not. It's just being set over to tomorrow. All right, court's gonna call 20, oh, I'm sorry. Okay, 26 CM 63 State of Wisconsin versus Elaine D. KARPINEN, appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Elaine KARPINEN appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. I would ask that the mailing address be changed to the Beacon, 615 East Washington Avenue. We would waive formal reading of the complaint, stand mute as to the misdemeanor charges. Well, it's one singular misdemeanor charge. And it would appear that she is eligible for public defender services.
Sure. Courts review the criminal complaint. I'll find probable cause. It's the one disorderly conduct misdemeanor. It's the bail bond.
I have no objection to a signature bond. I would ask that the defendant be banned from the Burger King that's located at the 2600 block of East Washington Avenue, and that she not use or possess any alcohol.
No objections?
No objections, thank you.
Okay, so ordered. We'll be adjourned. $500. You're always fine, unless I say something different. Okay. Correct.
Yes. Yes.
Oh, that's the last one.
Okay.
Was just joking about the post. I hope I didn't. I end up.
And then we'll
doing
be
two
there.
afterwards, so I don't see you there very often, but I see your colleagues quite often.
Who's the next one? Okay, thank you.
When we call these separately, or can we call them together?
We should, I think we can call them together.
Okay, they're all misdemeanors, so.
Yep.
So you want me to call them somewhere? No, if there was one, then I would, okay, all right, got it, got it. Yeah. It's a little weird being the jack of all trades commissioner, because I don't do the very often, you know? So, yeah, I haven't seen you before, I've seen him a few times. Spoken.
Let me ask one thing. Do you want to get your mail at the Beacon? Yeah. That's the mailing address they provide. Okay.
All right, courts are the call 25 CM 2954 and 26 CM 52. State of Wisconsin versus Kimberleyyann. Marie Wilken, appearances, please.
The state appears by Assistant District Attorney Thomas Valerio.
Ms. Kimberleyyann Wilken appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm, I believe the address on them is the Beacon. One of them does not appear to have an address on it. We would ask that the mailing address just be set to the Beacon, 615 East Washington Avenue. We would stand mute as to the misdemeanor charges, and it would appear that she is eligible for public defender services at this time. And I believe that she has a public defender appointment on another matter as it stands.
All right, courts review the criminal complaints. I'll find probable causes of misdemeanor charges, enter not guilty pleas on her behalf. That's the bail bond in each case, counsel.
This is also a case where a victim would like to speak, so I'd ask the beginning.
Sure, let's do that before we do bail bond. All right, with regards to the victim, if you could make whatever statement you want me to consider at this time, I'd appreciate that.
I want cash bail for her. I want her not to be at Bethel Lutheran because I go there the 2 days out of the week. That is the only place I go. I want no contact. None whatsoever. I don't want third party contact. I don't want her having her 2 boyfriends contact me like they have been. I just don't want nothing from her. I want cash bail because if I don't, honestly, if I'm gonna be honest, if there's no cash bail, she will run. She has a history of that. Not only that, but she there will be more charges coming if there is no way to protect me. She hasn't filed the injunction whatsoever as we're here in this criminal matter now.
Understood. I appreciate the statement, man. Thank you. Go ahead, Attorney Lara.
I have no objection to signature bonds in both the cases. In both the cases, I'm proposing a no contact with Jessica E.
Any objection? No, you can't, ma'am. It's not in your interest to say anything.
No objections. Thank you.
All right, so it'll be a signature bond. There's gonna be no contact. You understand that? I understand that, even through third party. I just wanna make that, if that's in your control, might not be in your control, but, all right, so as requested, the conditions are set. We'll be adjourned. Thanks, everyone.
What was the?
Yeah, we're done. Yeah, fair enough.